The ANC says it will accept and comply with the Electoral Court ruling, dismissing its bid to have the uMkhonto weSizwe party deregistered. The Electoral Court has ruled that the MK party met all the IEC requirements before the prescribed time for registrations. This means that the political newcomers can contest the upcoming elections.
For all of these reasons, it is iterated that the DCEO, in registering MK, complied with the requirements of Section 15 of the Electoral Commission Act, read with Section 16(1), the regulations and Annexure 1 thereto. We therefore find that there is nothing unlawful about the registration of MK by the DCEO on 7 September 2023. As regards costs, in line with the principle in Bywatch, costs are customarily not awarded in this court. We have not been persuaded to depart from this custom.
Judge Lebogang Modiba says the ANC's delay in submitting its appeal was irrational.
The ANC's explanation is irrational because it doesn't come close to justifying its delay in bringing the application late. It is not impugning the decision of the DCEO made on 4th August 2023. It is therefore irrelevant that it only became aware of this letter in January 2024. The ANC became aware of the impugned decision on 11 September 2023. At that stage, it took a decision to appeal the decision with the Electoral Commission in terms of Section 16, subsection 2. It lodged the appeal on 20th September 2023. The Electoral Commission considered the ANC's appeal and dismissed it on 24th November 2023.
Judge Modiba says the MK party met all statutory requirements.
The DCEO advised MK that he rejected its application for registration as a political party because the signature of its purported supporters on the deed of foundation showed patterns of discrepancies which indicate that the signatures were made by a person other than a voter. The DCEO further advised MK that it was not precluded from submitting a fresh application that complies with all the applicable requirements. MK supplemented its application by remedying the defects identified by the DCEO and resubmitted it on 30th August 2023. The DCEO reconsidered the application, found that it met all the applicable statutory and regulatory requirements, and registered MK as a political party on 7 September 2023.
To help us unpack this court judgment further, I'm now joined by Nkululeko Tselane, an attorney of the High Court. Afternoon, Nkululeko. Thanks very much for your time. Were you surprised at all by this ruling?
Good afternoon, and good afternoon to the listeners. No, I was not surprised at all. I think the judges very succinctly and very clearly articulated the real fundamental flaws that were in the application brought by the ANC. I think first and foremost, they did not provide strong enough reasons to really justify the excessive delay, which the court did find was both unreasonable and irrational. Secondly, on the issue of jurisdiction, it's very the Electoral Commission Act Section 20 is very clear. Section Chapter 5 is very clear that you can only review the decision of the commission, and this wasn't the decision of the commission; it was of the deputy CEO. So the ruling is not surprising, and it's also not surprising that it was a unanimous judgment given by the presiding officers.
Now, for us lay people, when your client, presents a case that they want you to take up as a lawyer. I mean, to these issues, because I mean, everyone has been saying pretty much what the judges had to say today, that the ANC kind of invited. It is responsible for the delays and not meeting, the minimum requirements for this case to be, for them to even, to succeed in this instance.
Yes. Well, look, at the end of the day, we all have access and all have the right to fully test the court and the laws and all the various avenues that we have. And of course, another important point is that there was no order as to costs. Now that is the practice that's in the Electoral Court, but it also highlights that there was a valid constitutional and legal matter that had to be dealt with, and the judges correctly dealt with it. So losing in court shouldn't be taken as a sign that you should have never gone to court. It should be taken as a sign that we're really testing our electoral and legal system.
And I know this is all hypothetical, but putting yourself in, the place of those people that the ANC would have, the lawyers that the ANC would have consulted and subsequently briefed, and assuming that they too saw what the judges saw, what could they have been hoping for? Still,
to be quite fair. The arguments brought by the ANC's legal team were very good. I think they really articulated the issue of jurisdiction, even though it is dismissed and it was essentially they were essentially unsuccessful. I think the way that they particularly referenced previous decisions of the court, whether it was the ACDP case and other past decisions, you could see that there was valid grounds that they could have won on. However, that wasn't what the court decided. I think right now, if I was them, I would be assessing my options, whether we decide to bring this in another platform, which would be the High Court, which has jurisdiction, or try to bring it again with condemnation now for the correct decision. That would have to be the next decision. However, you would have heard in the arguments from the ANC's legal counsels that if any application that they bring now would have to be brought in the ordinary course and would no longer be brought in the urgent manner. Now the problem with that is that we could have a situation where the matter is only heard after elections have been done. A similar issue did happen with the BLF with regards to their registration. However, things were not made complicated in that scenario because they didn't get a seat. However, with the MK party, we don't know that for a fact. So it could be a situation where their registration is then deemed as unlawful after the fact of elections, which would complicate things a lot more.
Well, from the rather terse statement that the ANC issued, they say they are going to comply, and no indication there that they intend to take the matter further.
Yes, I think now would probably be for them to focus on the next matter, which would be the matter regarding the trademark of the MK party, for them to perhaps focus on. However, of course, for that one, it's really just about the name and the logo of the party, not about the actual presence of the party on the ballot. So what we should also remember, at the end of the day, elections are the ultimate arbiter of public opinion. If the public doesn't want to vote for a particular party, they won't vote for a particular party. So we have to always allow and perhaps err on the side of inclusion instead of on exclusion, and allow the voters to be the ultimate deciders.
Well, speaking of that matter, it's going to be, tomorrow, of course, we're going to hear what the judgment is on the trademark matter. Just your thoughts very, very, very broadly.
Look, very broadly, I don't think that they're going to be successful I don't feel like the ANC will be successful in that matter. mainly similar to the same reasons that were ventilated in this matter, is that they did know about this matter. They didn't object to it in a timeous manner, and now they coming to the court with their hands not exactly clean. So without preempting it, I do think that the court would rule in favor of the MK party as it is currently registered and displayed.
Nkululeko Tselane, let's leave it there for today. Thank you very much for your time and insights.